Good day everyone, I am Limas from base HM3B, and today I am going to report Chapter 12, Laws Related to Tourism Investments and Finance. So our learning objectives enumerate the procedure in setting up a tourism-oriented business, explain the laws governing tourism investment and financing tourism-oriented projects, discuss the business models applicable to tourism projects, and discuss the limitation of foreign and tourism investments. So, in this chapter, it deals with the laws related to promotion, monitoring, and regulating of tourism investments and finance in the country. So, basically, this will tackle the participation of foreign investors as well as incentives given to Filipino case they will interest in the tourism industry. Foreign Investments Act of 1991, the law. So the term Philippine national shall mean a citizen of the Philippines or a domestic partnership or association wholly owned by citizens of the Philippines. So discussion of the law. Republic Act 7042 as amended by Republic Act 8179 March 25, 1996, also known as the Foreign Investment Act of 1991, provides for the policy that foreigners can now invest in all activities and enterprises in the Philippines except those covered in the negative lists. So, under the Foreign Investment Act of 1981, so a foreign national or equity must determine the kind of enterprise sought to be entered to, whether the enterprise is a domestic market enterprise or an export enterprise. Domestic market enterprise. It shall mean an enterprise which produces goods for sale or renders service to the domestic market entirely, or if exporting a portion of its output continually fails to export at least 60% thereof. So, in domestic market enterprise, foreigners can invest as much as 100% equity except in areas included in the negative list or in case the paid-in equity is less than the equivalent of $200,000. Then we have also export enterprise. So, shall mean an enterprise wherein a manufacturer, processor, or service, including tourism, enterprise export 60% or more of its output, or wherein a trader purchase products domestically and export 60% or more of such purchase. So, there are no restrictions on the extent of foreign ownership up to 100% in export enterprises. So, unless the products and service fall within the negative list A and B or utilize raw materials from depleting natural resources. Procedure for registration. So, a foreign national or entity not seeking to avail of incentives under the Omnibus Investments Code shall file an application of registration as follows. So, first we have corporation and partnership. So, with the Securities and Exchange Commission or SEC. So, the existing requirements for foreign corporate are name, verification slip, certified copy of board resolution, financial statements, certified copy of articles, foreign company information sheet, and proof of inward remittance. Then also we have single or sole proprietorship. So with the Bureau of Trade and Regulation, the Consumer Protection of the Department of Trade and Industry. Then we have also effect of failure to comply with the registration requirements and failure to secure the necessary SEC license. So first, administrative sanctions such as imposition of fines and forfeiture of benefits, Section 14, Foreign Investment Act. Then second, for foreign corporation, we have the criminal liability fine or imprisonment, Article 144 Corporation Code. Then foreign corporation cannot sue in the Philippine courts, Section 133 Corporation Code of the Philippines. And foreign corporation can be used in Philippine courts. So we have Section 133 Corporation Code. Investment in transportation, business, and public utilities. So the law, Article 12, the national economy and patrimony. So in the past chapters, we discussed this article. So Section 11, No franchise, certificate, or any other form of authorization for the operation of a public utility shall be granted except to citizens of the Philippines. And we have also the discussion of the law. So for common careers such as the airline, land, and water transportation business, the operation of such involve public service, which shall be granted only to citizens of the Philippines or to corporations or associations organized under the laws of the Philippines. So, in addition, the executive and managing officers of the corporation or association operating a transportation business shall be exclusive to citizens of the Philippines. Investment and travel agencies and tour operators. So the law. The following may apply for accreditation as tour operator. So first we have a resident or Filipino citizen, a partnership organized under the laws of the Philippines at least 60% of its capital being owned by Filipino citizens, and corporation organized under the laws of the Philippines at least 60% of the subscribed common or voting shares of stocks of which is owned by Filipino citizens, and the composition of this board of directors being at least 60% Filipinos. So we have discussion of the law. So the above provides the limitation of foreign participation to 40% for purposes of accreditation and operation of a travel agency and or tour operators by the Department of Tourism. So a memorandum order number 211 approving the 2006 investment priorities plan. So tourism has been classified as preferred activities pursuant to Article 29 of the Omnibus Investment Code of 1987. So we have investment in hotels, resorts, and other accommodation establishments. So the law. By reason of the enactment of Memorandum Order number 211 approving the 2006 Investment Priorities Plan, so April 4, 2006, tourism has been classified as preferred activities pursuant to Article 29 of the Omnibus Investment Code of 1987. So we have discussion of the law. So thus, in order for tourist accommodation facilities to be entitled for registration under the Investment Priorities Plan, an applicant must satisfy the Board of Investment that he is a citizen of the Philippines. The applicant is proposing to engage in a preferred project listed, and the applicant is capable of operating on a sound and efficient basis. Application of the retail trade law for restaurant and shops. So the law. Restaurant and other tourism-related establishments, such as department stores and shops, are governed by the laws on retail trade by reason for their business. So by the reason of the enactment of the Retail Trade Liberalization Act 2000, foreign investor may now engage in retail trade subject to capital requirements. So discussion of the law. So the following sales transactions are exempted under the coverage of the Retail Trade Liberalization Act of 2000 and are therefore allowed 100% foreign ownership participation. So, by a manufacturer, processor, laborer, or worker, then by a manufacturer of his product in a single outlet, irrespective of capitalization, and in a restaurant, incidental to the business. Applicable negotiable instruments and documents of the title. So the law. By way of introduction, the laws applicable for purposes of discussion of the different negotiable instruments and documents of title in tourism investments are as follows. So we have Act 2031, also known as the Negotiable Instrument Law. Then, Presidential Decree number 115 providing for the regulation of trust receipts transaction and warehouse receipt laws, Act of 2137. Financing. So the role of banks. The General Banking Law of 2000, Republic Act 8791, was enacted based on the following state policy. So the state recognizes the vital role of banks in providing an environment conducive to the sustained development of the national economy, and second is the fiduciary nature of banks that requires high standards of integrity and performance. Credit cards. So the law. Section 3. Assess, device means any card, plate, code, account number, personal identification number, or other telecommunications service, equipment, or instrumental identifier. Then Section 3. F. Credit card is any card, plate, coupon, book, or other credit device existing for the purpose of obtaining money, goods, property, labor, or services, or anything of value on credit. Then section 3, open-end credit plan. So means a consumer credit extended or an account pursuant to a plan under. So, discussion of the law. So, defined as a small card establishing the right of a holder to credit on certain purchases such as meals, lodging, gasoline, or merchandise. It is a well-sized identification card that enables its holder to buy products and obtain services on credit from one or a variety of business firms. Special Economic Zone Act of 1995, Republic Act 7916. So the law provides for the legal framework and mechanism for the creation, operation, administration, and coordination of special economic zones in the Philippines, creating for his purpose, so the Philippine Economic Zone Authority or PEZA, and for other purposes. So, the PEZA shall consider for registration tourist-oriented enterprises to be located in PEZA-registered tourism development zones or tourism estates which are enclosed by the DOT as enterprises. So, that will be established and operated with foreign tourists as primary clienteles. Business models. The law. Joint venture. In a joint venture, which is similar to partnership, two or more persons bind themselves to contribute money, property, or industry with the intention of dividing the profits among themselves. So, discussion of the law. So, a joint venture is distinguished from a partnership in such way that joint venture may or may not attain a juridical personality. So, if qualified as a partnership under the Civil Code, it is taxable as a corporation, and if not qualified as a partnership, it has no juridical personality. So, to constitute a joint venture, there must be an agreement entered into an undertaking in objects of which parties have community of interests and common purpose in performance. Franchising. So, the law. A franchise is a privilege given to a dealer by a franchise service organization to sell their franchisor's product or service in a given area with or without exclusivity. So, discussion of the law. A franchise is a license from the owner of a trademark or trade name permitting another to sell a product or service under that name or mark. So, more broadly stated, a franchise has evolved into an elaborate agreement under which the franchise undertakes to conduct a business or sell a product or service in accordance with methods and procedure prescribed by the franchisor. Taxes. The law. Tax on income. So, the taxable income of a domestic includes income earned from all sources. So, a resident foreign corporation is one considered doing business in the Philippines and is taxed on the net Philippine source income. Then we have value-added taxes. So, a 12% value-added tax is imposed on any person who, in the course of trade or business, sells, barters, exchange, leases, good or properties, renders services, or engage in a similar transaction, and who imports goods. Then we have percentage taxes. So, persons whose annual gross receipts do not exceed 550,000 pesos are exempt from payment or value-added tax, but shall pay a percentage tax equivalent to 3% on quarterly sales. Then, exercise taxes. So, exercise tax is imposed on certain specified goods and manufactured or product for consumption in the Philippines for domestic sale or consumption for any disposition in those imported. Customs and import duties. So, custom duties are taxes on imports or exports. So, exportation begins from the time the carrying vessels or aircraft enters Philippine territorial jurisdiction with the intention to unload to the time their goods are released. Then, travel taxes. So, under President Decree number 1183, as amended by PD 1205, Batas Pangbansa 38, and Executive Order 283, the Filipinos and other nationals traveling to other countries are required to pay travel tax before departure from the Philippines. Barangay Microbusiness Enterprise Law. So the law. The Barangay Microbusiness Enterprises Act of 2000, Republic Act 9178, July 22, 2002, was enacted to hasten the country's economic development by encouraging the formation and growth of barangay microbusiness enterprises, which effectively serve as seedbeds of Filipino entrepreneurial talents. So, discussion of the law. So, all BMBs shall be exempted from income tax for income arising from the operation of the enterprise. So, the local government units, LGUs, are encouraged either to reduce the amount of local taxes, fees, and charge imposed or to exempt the BMBE from local taxes, fees, and charges. So the BMBEs shall be exempt from the coverage of the minimum wage law, provided that all employees covered under the Act shall be entitled to the same benefits given to any regular employee, such as social security and healthcare benefits. So that's all on my report about Chapter 12, Laws Related to Tourism Investments and Finance. So I hope that you've learned something. Thank you for listening and God bless.